Here?
Here.
Here.
Okay, thank you. Please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, thank you. Item 1 of our agenda is the approval of the minutes of the August 17th board meeting. Are there any additions or corrections to the minutes?
I'll move approval.
Second?
Okay, it's been moved and seconded to approve the August 17th board meeting minutes. All in favor?
Aye.
Aye. Thank you. The next item is a public comment item on the agenda. This is the opportunity for the public to comment on items that are not on the agenda. If you would like to make a public comment, I invite you to come forward and state your name for the record. Okay, seeing none. Item 3 is the executive officer's statement. Julie, would you like to give your report?
Yes, good morning, members. It seems like many months since we've all been together, but it's nice to be back in Sacramento. I've been doing a little bit of traveling on behalf of our board in middle of August, excuse me. I was at the National Conference of VOCA Administrators and Compensation Programs in Washington, D.C. It's the annual joint conference, extremely well attended. I had the opportunity to present in a number of panel discussions. And of course, everyone always wants to know what's California doing and how do you do that much? So they were very impressed with all the work that we've been doing over the last year. So it's always a pleasure to be able to interact with my colleagues. In fact, later this morning, I have a conference call with a number of the states who are interested in having some conversations with OVC about the funding formula for the comp programs. We're finding a number of states are really struggling to meet the needs of their victims. And I did have the opportunity to meet the new OVC director and chat with her a bit about some of the issues that we're all facing in the comp programs across the country. In addition to traveling to Washington, D.C., last week, Deputy Executive Officer Christy Munson and I attended a conference at the University of Oregon. This is a joint conference that we co-sponsored with the Police Department of the University of Oregon. And I want to particularly call out Anita Ahuja for her efforts really putting this together with Chief Carmichael. This is our second annual Leave No Victim Behind conference. Obviously, that means that last year was our first one, and at that time, Chief Carmichael was the Chief of Police at the University of California at Davis. And that conference focused on underserved populations and came on the heels of all the work that we had done on behalf of OVC through our grant, identifying underserved communities and then developing strategies and actually implementing those strategies to better provide information about our program so that there's awareness of it as well as improved means of access. And you're aware of many of the strategies that we have implemented, including translating all of our application and documents and letters to victims into the 13 most common languages spoken throughout California. This time, the conference focused on responding and being prepared for mass violence. It was a very intense, almost 3 days of listening to law enforcement and victim programs from across the country, and the idea really was to build those partnerships to plan for the inevitability of mass violence occurring. So there were many case studies about violence, particularly on college campuses, but it was very instructive for all of us. And again, we are putting an emphasis in our outreach plan on working with law enforcement. So Christy made a very nice presentation about the work that we're doing here. And again, California was very well received. We are approaching October, which is Domestic Violence Awareness Month, and we are preparing a number of awareness activities. This year, we are partnering with Sacramento-based Weave who's one of our strong partners in this region, and we will be proactively conducting media interviews with them. Also, I would like to let you know that at long last, we are at the beginning stages of our efforts to conduct a strategic planning process in partnership with the Office of Emergency Services, who administers the assistance side of our VOCA program. So we have reached agreement on the process, and we have recently posted a request for offers. So we are looking to bring on a consultant to work with us, and we will be jointly managing this effort and bringing in our other state partners as well as stakeholders. So both OES and our board have announced this to our stakeholders. So if you hear comments, I'd love to know about that. We really want everyone to know that we're doing this and the very important reasons underlying it. And I want to thank you, Madam Chair, for your support in helping us forge this partnership with OES. It's time.
Keep pushing a little bit, that's all.
All right.
That's all it takes.
Yes. So we're hoping to launch this fall and have it done by the end of next year.
And please keep me informed as to progress, because I'm still willing to push.
Thank you so much.
And I want to thank Christy for, maybe you're not.
I'm
finished
done.
yet. Oh, I wanted to thank Christy also for the work at the University of Oregon.
And Anita.
And Anita.
Yes,
Thank you,
both.
ladies, thank you.
All right. That concludes my report. Thank you.
Okay, super. Any questions of Julie?
No.
Okay. Moving on to item number 4 on the agenda is the legislative update. And Julie, I'm going to ask you to do that as well.
Yes, I'd be happy to do that. You have the written report in your binder. You'll see all the bills that we've been following this year. A number of them are on the governor's desk. I'll just point out that the governor did sign AB 212, which is our claims bill for the PC 4900 cases. Unless you have any questions about any of the bills, I will just let the report speak for itself.
Nope, it definitely is EBR season. We're all
Yes.
taking our homework home every night to read the enrolled bill reports to give our suggestions and recommendations to the governor. So when he returns from New York, he will have quite an undertaking of bills to review, but he reviews every one of them. So thank you. Does anybody have any questions of the bills that are in the report that we have?
No.
Okay. Then we'll move on in the agenda to item number 5, which is the Penal Code Section 4900 claim of George Skull that will be presented by our Chief Counsel, Lorinda Delaney. Sorry, Lorinda. Lorinda, would you please brief us on this item?
Thank you, Madam Chair. George Scholl seeks compensation for his wrongful conviction and incarceration pursuant to Penal Code Section 4900. In November 1989, in Santa Clara County, Mr. Scholl pleaded guilty to misdemeanor molest and felony assault and admitted a great bodily injury enhancement. Those offenses related to an incident against victim Nina T. The same time, with regard to a separate victim, Mary D., Mr. Scholl proclaimed his innocence but pleaded no contest to felony sexual battery and felony assault and admitted that he used a deadly weapon during the offenses. The trial court sentenced Mr. Scholl to 5 years for the offenses concerning Nina T. and a concurrent term of 5 years for the offenses concerning Mary D. Mr. Scholl was released from prison in June 1992 and his parole terminated in July 1994. Mr. Scholl filed his first Penal Code Section 4900 claim in June 2010, which the board rejected as untimely because it was filed beyond the 2-year period authorized by statute. On April 29, 2016, Mr. Scholl obtained a finding of factual innocence from the Santa Clara County Superior Court for the offenses related to Mary D. He did not challenge his convictions related to Nina T. He submitted another Penal Code Section 4900 claim on October 11, 2016. The hearing officer recommends that the claim be denied for 3 reasons. First, Penal Code Section 4900 refers to a claim and does not on its face authorize an individual to pursue multiple claims before the board for the same conviction. Mr. Scholl's original claim, again, was rejected in 2010. Second, Penal Code Section 4900 requires that claims be filed within 2 years of acquittal, a pardon, or a release from custody. Those events for Mr. Scholl occurred in 1992 and 1994, respectively, making his claim untimely. Third, Penal Code Section 4903 requires a showing of injury. Mr. Scholl cannot demonstrate injury here because he was serving a concurrent valid sentence for convictions relating to the offenses against Nina T. The finding that Mr. Scholl obtained pursuant to Penal Code Section 851.865 does not bind the board and does not assist Mr. Scholl because that section refers back to Sections 4900 and 4904, which require a finding of injury, and Mr. Scholl cannot make that finding. Here, representing the Attorney General's office is Clifford Zoll, Deputy Attorney General, and on his own behalf, George Scholl.
Gentlemen, would you please come to the table? Make your presentations. And I would ask that you, once seated, state your name for the record, and we'll begin first with the Attorney General's office.
Good morning, Cliff Zoll, that's Z like a zebra, A-L-L, from the Attorney General's office.
And Mr. Skull, you can introduce yourself and then reintroduce yourself when you.
My name is George Edward Shaw. Please,
Okay,
the
thank you.
claimant in this matter.
Thank you. Would the Attorney General's office please make their statement at this time?
Just briefly, I believe the hearing officer very thoroughly examined the claim and explained for a variety of reasons why the claim should be denied. I think really what it boils down to is that Mr. Scholl cannot show that but for the conviction that he obtained a finding of factual innocence on, that he would not have been incarcerated. In other words, basically, he would have been incarcerated anyway because he had a concurrent sentence, and therefore he really is not the type of person that the legislature intended when it set up the statutory scheme here to compensate. And again, if the board has any questions of me or wishes me to respond to Mr. Scholl's presentation, I'd be happy to.
I think the legislature intentions are about a type of case, not a type of person, just to clarify. Okay, Mr. Scholl, would you like to make a statement?
Yes, ma'am. I want to thank the board. First of all, at the outset, I would say that if the board goes ahead with the denial, that is an effect of a resentencing, and that can really only be done by Judge Fogel, who I believe is still an active judge. If you were to deny the claim, you are effectively saying that I would have gotten the same sentence for only count 3. Judge Fogel imposed this sentence for counts 3, 5, and 7, 3 serious felonies for 5 years. And if you went ahead and denied the claim, you're saying that I would have gotten the same amount of time for only count 3, and that's just not right. He sentenced me for 3 serious felonies, and I want to bring to the board's attention that these were 2 separate cases out of different cities, and the wrongful arrest in count 5 and 7 occurred a month and a half after the count 3 offense. I know you've read a lot of my material, but it bears repeating that. So that's just at the outset. I mean, almost everything I could say after that would be academic, because that has to have judicial oversight in order to deny the claim. There's just no other way I can see that. But the other thing is with count 3, there was actual wrongful wording. The lady said that I admitted to it. I pleaded no contest. Everything in the preliminary transcripts will indicate that there was never any deadly weapon. There was no deadly weapon. I did place my hands on the upper arms of my victim and pushed her down hard. I never intended for that to happen, for her to sustain broken teeth and things like that. And after it occurred, I ran off just mortified at what I had done, never before or since. But getting back to the sentence again, both of these cases carried 5 years, respectively. When Judge Fogel imposed the 5 years, that was 5 years for sexual battery with a deadly weapon, assault with a deadly weapon, and it was a wrongful. Actually, the count 3 should have been assault with assault with force likely to produce great bodily injury. So that was wrongfully worded, so that calls into question count 3 completely, the legitimacy and the credibility of count 3.
Has that been brought to the court's attention?
Yes, I've mentioned it in previous submissions, ma'am, and I mentioned it also in my last hearing here. I've said that needs an innocence project all to itself.
That hasn't been taken up by the court. It's been mentioned, but it hasn't been adjudicated by the court.
No, ma'am, it hasn't been adjudicated. I did mention it to the Assistant District Attorney of Santa Clara County, but he chose to keep it undisturbed at this time. So, but there was never any deadly weapon, and I just object to that so strongly. The other thing is I have inaccurately worded, and that the misdemeanor charge was just a misdemeanor, and it was a concurrent county jail sentence, and I didn't think that this should be brought up because that would have been, based on my exemplary record after prison, before prison, I received a certificate of rehabilitation, and this misdemeanor was expunged once I was exonerated of these charges. So, but anyways, getting back to the sentencing, both of these cases carried 5 years, and so once Judge Fogel imposed 5 years, it was 5 years collectively for all the felonies, and I was found factually innocent. And that should be a triggering event because order of factual innocence carries the same weight and validity as a pardon. So that should be a triggering event, and so that was well within the time frame to file a claim. And the doctrine of res judicata should not be enforced in this instance because I was given an order of factual innocence plus Senate Bill 618, and just on that note very quickly, I'd asked Ms. Simpton last time I was here if she could get some input from former Senator Leno or Mayor Steinberg, who were co-authors of Senate Bill 618, but I guess they were unavailable for comment. But so I believe that since they were completely separate cases, that counts 5 and 7 should be 1/2 of the actual amount of prison time. And I might add very quickly that I was placed in level 4 custody in Soledad and Vacaville with very, very dangerous inmates, murderers, attempted murderers, the worst of the worst. And I had no business being in there. Had it been just count 3 only, I would have been in a fire camp in a minimum state prison, and I had numerous assaults. I was beaten, and I was in protective custody because of these charges. And I've even mentioned in my submission that people have been killed for these kind of charges. And so I never should have been subjected to some of these inmates. And so, and just the whole registration, the 20 years of inability to find work, the inability to pay into Social Security, what it did to my late mom, my family, having your name, photo on the Megan's Law web. I had to go through all of that. And on top of that, I had a wrongful felonious registration arrest. And that never should have happened. If were it not for the fact 5 and 7, that never would have happened. And that was a terribly traumatic incident to go through. And I came at the risk of repeating myself, I came very, very close to 25 years to life as a third striker back then. So I just believe that this was a significant chunk, part and parcel of the 5 years. And for anyone to say that I would have gotten the same time on count 3, that doesn't even take into consideration all of the terrible registration, the housing, I'm working now, and I would have been working, but it's such a tragic miscarriage of justice. And I just wanted to say that. I didn't mean to go on so long.
You absolutely have your right to go on. That's absolutely, and thank you.
Thank you.
I have a couple of questions, Lorinda, of you, if I may. Can you explain why untimeliness impacted this request and not the 2010 request, or do I have confusion around that?
The untimeliness affected both requests. In 2010, his Penal Code Section 4900 claim was rejected as untimely, and because of the untimeliness, we didn't have jurisdiction to hear it. This one could also be rejected for untimely because the triggering events occurred in 1992 and 1994. Currently, the statute is not written to allow a finding of factual innocence to be a triggering event for the 2-year statute of limitations.
Okay, and that was on the record in 2010 from this board?
Yes.
Okay. Also, would you go into some depth of explanation on the 851.865 and how it does not apply to the application?
Yes. And under Penal Code Section 851.865, as this board is aware, if a claimant has a finding of factual innocence from a superior court, that finding is binding on this board and can mandate that we recommend payment to the legislature. But the plain language of 851.865 refers back to 4900 and 4904, which suggests that the jurisdictional requirements of Section 4900 must still be met. So we're bound by the finding of factual innocence, but the claimant must still show that they timely filed, that they suffered injury, and that they were in prison, and it was for a felony offense as opposed to a misdemeanor. Those jurisdictional requirements have not been met here.
Is incarceration evidence of injury?
Incarceration is evidence of injury, but that doesn't aid Mr. Scholl in this case because he received a 5-year sentence for the offenses against Nina T, and those convictions have not been challenged. He also received a 5-year concurrent sentence for the offenses involving Mary D, so there was no time served on the offenses concerning Mary D that would not also have been served on the offenses concerning Nina T.
If they were not, if the judge had not made them concurrent, then that would change this.
That would change it, yes, Madam Chair. It would have also changed it, for example, had Mr. Scholl received a sentence of 6 years on the offenses concerning Mary D and only 5 years on Nina T, because then there'd be that 1 year where he was serving time on the invalid conviction only. Here, he was serving time on both convictions at the same time. And I might add that the sentence was not more harsh when you look at page 5 of the proposed decision. According to the trial court, Judge Vogel, at the time of sentencing, he focused on the charges involving Nina T exclusively and accepted for the moment that Mr. Scholl did not commit the charges involving Mary D. And even assuming only the offenses against Nina T, the trial court determined based on the injuries that occurred that it was a prison sentence and would have imposed the 5 years.
Ma'am, may I say something, please?
Yes, of course.
I'm sorry. Yeah, the thing is that whether you say 5 and 7 ran concurrent with count 3 or count 3 ran concurrent with counts 5 or 7, I think is not material because these were three. Look, I didn't accept a plea deal of count 3 only. It wasn't a plea deal. It was a plea deal arrangement of 3 serious felonies of 5 years. And when you take count 5 and 7 taken together were shocking, horrible crimes, appalling crimes. And I just don't see how you can say that I didn't do any extra time for counts 5 and 7. They were horrible crimes. And that's my point here is that if the plea deal reduced effectively each of those cases to 2.5 years and 2.5 years or 1.25 years of actual time served. I didn't take a plea deal for count 3. And besides that, as I've said repeatedly in my submissions, were absent count 5 and 7. I had a whole range of options that would have been open to me. We could have gone to trial. The judge could have given me a much shorter sentence, plea deal sentence. 5 and 7 were just horrible crimes. 7 was a sexual battery. That's life-changing. And then you throw in count 5, the assault with a deadly weapon. These are horrific crimes. And like I said repeatedly in my submissions, I did something stupid and bad once. There would have been so many other opportunities and options open to me, even with count 3. And I'm almost speechless because it boggles the mind at how bad I'm still reeling from it. I'm a shuttle driver. And thank God I'm working. I'm lucky to have that. I had to take today off to be here. But it's just, half my life has been consumed by this. Yeah. You can't dismiss 5 and 7. They were just horrific crimes. Everybody's entitled to make a mistake, a bad mistake, and most of society will give you a second chance. Count 3 was despicable. And even at count 3, they worded it wrong. Nothing in the preliminary transcripts indicates I had a deadly weapon. And I grabbed the girl by her upper arms and threw her down. I thought she might get scraped, but I didn't think she'd have broken teeth, and that was a horrible thing, and I always regret that momentary act of insanity. And so I just hope that you take that in consideration. They both were 5 years.
Right.
Yeah.
Right.
Thank you.
Thank you, sir. Do we have any other questions of either the Attorney General or our counsel or Mr.
No,
Saul?
I have none.
Okay.
I'll move staff's recommendation.
Is there a second?
I'll second it.
It's been moved and seconded to accept staff's recommendation on the item number 5, the Penal Code 4900 claim of George Scholl. All in favor?
Aye.
Opposed? Aye. All right, thank you very much, sir.
Thank you, ma'am. And thank you, board. Thank you. Am I excused, ma'am?
Yes, you are, sir. Thank you very much.
Thank you.
And the Attorney General is as well. Okay. We will now move to the Victims' Compensation Program portion of our agenda. The next item is a proposal to approve a Trauma Recovery Center grant award that will be presented by Ava Watson, Program Development and Analyst Manager. Good morning.
Good morning, board members.
Morning.
I'm Ava Watson, Manager of the Program Development and Analysis section at Cal VCB. Today, I'm presenting the board item requesting approval of the proposal to award one additional Trauma Recovery Center grant for fiscal year 2017-2018 funding. Partnerships for Trauma Recovery submitted a grant application in response to the second notice of funds available that was posted April 10th, 2017 due to remaining funds for fiscal year 17-18 awards. The application did not receive the minimum score required to be recommended for funding, and Partnerships for Trauma Recovery was noticed of the decision by Cal VCB on May 18th, 2017. Partnerships for Trauma Recovery submitted a timely appeal that was reviewed by Cal VCB legal and executive staff. And after careful consideration of the applicant's appeal, Partnerships for Trauma Recovery is now being recommended for funding for an award in the amount of $258,573. Partnerships for Trauma Recovery will be a new trauma recovery center. The amount recommended is 100% of the amount requested. This award will be funded from the restitution fund, leaving $342,283 of the annual $2 million restitution fund allocation for TRC grants. And today, representatives from Partnerships for Trauma Recovery are present. We have Monica Parikh, founder and executive director, and Giannini Pellegrini, development coordinator.
Great, thank you very much. Would the two ladies, as you just introduced, would they like to make a statement or do they have, they don't need to,
Yeah.
They can if they wish,
They are just
since they're
present.
here, since they made the effort of being here today. Okay, is there any discussion on this item?
No, do we need a motion?
Yeah, we do.
Okay, I'll move the item.
Okay, it's been moved and seconded to accept the proposal to approve a Trauma Recovery Center grant award. All in favor?
Aye.
Aye, and thank you very much.
Thank you.
Okay, the board will now convene into closed session pursuant to Government Code Section 11126C3 to discuss numbers 1 through 39 of the Victims' Compensation Program.